The fundamental relationship between state governments and federal civil rights enforcement has officially entered a completely unprecedented era. For decades, state legislatures operated under the assumption that they could aggressively restrict firearm ownership without ever facing direct federal opposition. That historical assumption was permanently shattered this afternoon by the United States Department of Justice. A massive paradigm shift is currently unfolding, fundamentally transforming how the federal government actively protects the Second Amendment rights of everyday American citizens. Operating strictly under Executive Order 14206, the current administration has initiated an aggressive legal counteroffensive. The specific directive mandates that the federal government must take affirmative legal steps to ensure fundamental constitutional liberties remain completely uninfringed. Immediately following her appointment, Assistant Attorney General Harmeet Dillon launched the first ever federal investigation into state-level Second Amendment violations. This historic action fundamentally repositioned the federal apparatus from a passive observer to an aggressive defender of civil liberties. To sustain this massive legal effort, the Civil Rights Division has formally established a highly dedicated Second Amendment section. This specialized team of federal attorneys is actively bringing constitutional cases before district and appellate courts across the entire country today. The primary target of this newly formed federal legal strike force is currently the Commonwealth of Virginia. The state government in Richmond is currently utilizing its legislative majorities to aggressively advance over 20 highly restrictive bills targeting gun ownership. The Department of Justice has officially drawn an absolute red line against this sweeping legislative agenda. Federal lawyers recently issued a severe demand letter directly to Governor Abigail Spanberger, officially putting her administration on extremely strict legal notice. This official correspondence serves as a formal declaration that if the governor signs these pending bills, she faces immediate federal litigation. The Civil Rights Division explicitly threatened to aggressively seek injunctive relief to permanently halt the enforcement of these unconstitutional mandates. A primary focus of the federal warning involves Senate Bill 749, which severely restricts modern sporting rifles. The legislation specifically targets the manufacturing, purchasing, and selling of highly popular semi-automatic firearms, including the ubiquitous AR-15. Federal attorneys are carefully utilizing recent judicial precedents in a highly strategic, step-by-step method to dismantle this specific legislation. They explicitly cited a unanimous Supreme Court opinion from last year directly regarding the case of Smith and Wesson versus Mexico. That specific judicial decision clearly recognized that AR-15 style rifles are overwhelmingly legal and commonly purchased by ordinary consumers. Furthermore, the federal letter strategically weaponized a dissenting opinion from Justice Sotomayor in the Garland versus Cargill case. Even justices who traditionally oppose broad firearm protections have formally acknowledged on the legal record that these rifles are commonly available. The federal government forcefully reminded Virginia that tens of millions of perfectly peaceful Americans currently possess these specific defensive platforms. According to established constitutional methodology, the legal burden rests entirely upon the government to justify any outright prohibition. State lawmakers must definitively prove that a highly specific weapon is both dangerous and completely unusual to ban it from civilian hands. Because these semi-automatic rifles are undeniably common, they automatically secure absolute constitutional protection under the Second Amendment. The federal government explicitly warned that attempting to criminalize the purchase and sale of these common arms violates foundational legal principles completely. In addition to targeting rifles, Virginia lawmakers are simultaneously attempting to completely outlaw standard capacity magazines holding more than 10 rounds. This deeply draconian measure deliberately turns a basic administrative regulation into an immediate and massive confiscation mandate for millions of citizens. The state government aggressively removed standard grandfather protections from this pending legislation entirely. Consequently, an everyday citizen legally owning a 30-round magazine automatically becomes a highly serious criminal the exact moment the governor signs the bill. Virginia officially classifies the mere retention of this extremely common plastic and metal component as a Class 1 misdemeanor. This specific charge carries a truly devastating maximum punishment of up to 12 full months completely locked inside a local jail cell. The Department of Justice explicitly condemns these types of confiscatory bans because magazines are fundamentally essential to firearm operation. Under recent constitutional rulings, state governments absolutely cannot selectively prohibit the exact components necessary to make a protected right functionally exercisable. The federal strategy heavily relies upon the historic Heller decision from 2008 to combat these state-level overreaches. That landmark ruling already established the deeply historical principle that states cannot arbitrarily ban firearms deeply utilized for completely lawful purposes. Because the Supreme Court fully completed this foundational legal work 18 years ago, states cannot continually demand fresh constitutional reassessments. The federal government asserts that these sweeping state laws are fundamentally presumed unconstitutional unless the state provides explicit historical evidence immediately. State lawmakers must be loaded to actively trigger a criminal charge. Under this deeply flawed framework, a peaceful citizen faces severe criminal prosecution for simply transporting a completely unloaded, entirely non-functional weapon. This draconian carry restriction blatantly ignores highly vetted concealed handgun permits, directly exposing perfectly peaceful citizens to 12 months in jail. By arbitrarily classifying incredibly common cosmetic features, like threaded barrels or telescoping stocks, as strictly illegal, the state builds massive enforcement traps. The state government is intentionally designing an impossible legal labyrinth, where legal ownership becomes practically impossible to ever exercise in public. A completely vetted, off-duty police officer is immediately classified as a dangerous criminal if they mistakenly transport their personal weapons. This creates an incredibly bizarre legal reality, where an individual's fundamental constitutional rights practically vanish the exact moment they step completely outside. To further suffocate constitutional rights, Virginia is drastically expanding totally invisible gun-free zones through highly deceptive legislation like House Bill 9009. This deeply dystopian state law aggressively expands the highly restricted radius located directly around voting locations from 40 FT to 100 FT. This massive legislative mandate deliberately creates a completely unprecedented geographical expansion that fully applies year-round at absolutely obscure municipal buildings. A completely innocent citizen could easily traverse these massive invisible boundaries while driving to simply get coffee, instantly committing a serious crime. This deliberate weaponization of geographical space represents exactly the type of heavily unconstitutional behavior the Supreme Court is currently preparing to dismantle. State legislatures are desperately attempting to create vast legal workarounds where citizen carry permits are rendered completely worthless because everywhere becomes entirely off limits. The federal judiciary is actively signaling that state governments cannot simply label entire massive neighborhoods as sensitive places. They are heavily expected to strictly eliminate these extreme location restrictions in the highly anticipated upcoming decision of Woolford versus Lopez. Strategically, the federal government has fully recognized that outlandish and highly restrictive state-level laws present the absolute best legal opportunities. The Department of Justice is actively choosing to aggressively hammer misbehaving state governments rather than fighting extremely complex battles over federal statutes. The highest courts are traditionally far more deferential to national gun control laws officially passed directly by the United States Congress. The statistical odds of the Supreme Court actively upholding a draconian state-level ban are significantly lower than upholding a federal restriction. Therefore, the Department of Justice made a highly calculated strategic decision to carefully maintain a permanent laser focus entirely upon state overreach. By relentlessly attacking rogue state laws, the federal government safely constructs an impenetrable fortress of pro-freedom legal precedents for the future. If you analyze the modern history of Second Amendment jurisprudence, this specific state-focused litigation strategy becomes completely and undeniably obvious. In the landmark Heller decision, the highest court explicitly struck down a total handgun ban operating strictly within the District of Columbia. The McDonald decision successfully knocked out the exact same type of absolute handgun prohibition operating strictly within the vast city of Chicago. Furthermore, the Caetano decision completely invalidated the state of Massachusetts and their completely absolute ban strictly regarding modern electronic stun guns. The massive Bruen decision effectively demolished the highly restrictive, entirely discretionary permit regimes that heavily plagued citizens located within New York. In stark contrast, the recent Rahimi case specifically examined a federal statute, and the highest court ultimately decided to actively uphold it. Reading the judicial tea leaves clearly indicates that modern federal courts are completely willing to aggressively slap down insane anti-gun state laws. The Department of Justice clearly understands that targeting state and local laws represents the safest and most highly effective constitutional legal pathway. This specific strategic focus perfectly explains why Harmeet Dillon is directing the full terrifying power of the Civil Rights Division directly at Virginia. To actively avoid massive and completely unnecessary federal litigation, federal attorneys recently offered a final diplomatic path specifically moving forward today. The highly specialized Second Amendment section officially stated they are currently standing completely ready to actively meet with the Virginia Attorney General. However, their severe warning letter decisively concluded by forcefully reiterating that the rights of law-abiding American citizens shall absolutely not be infringed. Having the full unyielding weight of the United States Department of Justice aggressively coming down upon a rogue state is truly historic. The massive federal cavalry has finally arrived to help hold the line, heavily ensuring fundamental civil liberties remain permanently protected from absolute state overreach. If this video helped you thoroughly understand the current, highly severe legal threats heavily targeting your fundamental Second Amendment rights today, please firmly hit the subscribe button and strictly ring the bell. Please actively share this incredibly vital legal update extensively with at least one fellow law-abiding gun owner so they strictly remain highly informed. Stay deeply informed regarding the continuous shifts in the massive legal landscape. Remain safely and completely compliant with the law, and I will strictly see you next time.